All right, we're doing that show because tomorrow's one of those days, man. Tomorrow's one of those days. Months ago, when we released the docket, what was on the docket for the Supreme Court coming up, we said this one was going to be one of the most transformative cycles for the Supreme Court ever. America will look different after this docket. It will look different. For better or for worse, the Supreme Court is going to rule on a number of cases that will change what America is. Tomorrow's one of those big ones. Tomorrow's one of those decisions, one of those cases that will change America. Possibly. It's one of those decisions. Depending on how it goes, the idea of what America is, what it stands for, and who is American could change forever. Forever. Scotty, what's up?
I know this is not the way you're going, but I just want to give you a quick update that happened while you're doing research. The Supreme Court ruled on another one just now. The Supreme Court sided with Christian therapists, rejecting Colorado's law that prohibits mental health professionals from trying to change sexual orientations and gender identity of LGBTQ. So we knew that was going to happen.
Yeah, we knew that.
We talked about that, and now that's official.
Yeah, that one's a softball. That one's a softball for the Supreme Court. Doesn't cost them much in terms of optics or any type of conflict with the conservative base. That's an easy one for them. No mental health treatment, to facilitate transgender gender affirming surgery. Okay. That one's an easy one. This one's tougher. This one's tougher like the tariff decision was tougher for the Supreme Court. End birthright citizenship. The ending of birthright citizenship. Now, this has been kicked around in conservative circles and evangelical circles for a while. On Trump's first day of this term, he signed an executive order to end it. It was immediately blocked in a number of courts. The Trump administration decided to forego the appellate court's decision and send it straight to the Supreme Court. The U.S. government is being sued by ACLU representing and a couple other advocacy groups representing parents, expectant parents, immigrants who are expected to have a child here on U.S. soil who would be affected by this decision. So there's a group of expectant parents being represented in front of the Supreme Court against the U.S. government. This will begin Wednesday. This will begin tomorrow. Now, this all is concerning the 14th Amendment. The 14th Amendment and a 1898 court decision that solidified it. U.S. versus Wong Kim Ark. U.S. versus Wong Kim Ark. So the 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. All persons born or naturalized in the United States and subject to the jurisdiction thereof. Okay. There's their beef with the 14th Amendment. There's their in. They're trying to poke a hole through that wording, and they're going to find out if the hole's big enough for the Supreme Court to see the other side. The 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof. Okay. Not only do they aim, now this executive order aims directly to contradict the 14th Amendment. That is the target of the executive order, the 14th Amendment. But they must also get over another hurdle. The Supreme Court's decision in 1898, U.S. versus Wong Kim Ark. It was a very, at the time, considered to be a very solid opinion and decision that was the bedrock of anything involving this going forward. So that's the Trump administration's two hurdles. Undo the 14th Amendment and have the Supreme Court reinterpret, redecide on the U.S. Kim Wong-Ark decision. Reinterpret that. Two main hurdles. Two targets. You can distill it down into that. Everything you're going to hear, those are the hurdles for the Trump administration. Okay? Now, the Justice Department is saying, Solicitor General, who's arguing the case, John Sauer, they are saying that the passage has been misread for decades. Misread. Okay? And it should never have been interpreted to grant citizenship to children of hundreds of thousands of undocumented immigrants. They say it incentivizes, the tourism, the birth tourism to the United States. Illegal immigrants getting here any way they can to have a baby and have a citizen in the United States. Quote, birthright citizenship was not meant for people taking vacations to become permanent citizens of the United States of America and bringing their families with them, all the time laughing at the suckers that we are. That is President Donald J. Trump. Just so you're clear on how he feels about this. All right? All right? Now, it was immediately challenged, like I said, by judges in Democratic-led states, by immigrant advocacy groups. They said it would lead to chaos and uncertainty for parents who would have to prove their immigration status for the babies to be citizens. This is very interesting. As I take a look at it, check out the arguments, and try to decide how good of a chance does the Justice Department, John Sauer, and the Trump administration have. What are their chances? Well, we talked about Section 2 of the Voter Rights, the Voter Rights Act, the majority-minority districts. We talked about that one, and I was 50-50 on that. And I saw a little light at the end of the tunnel where they could, revisit the demographics in these states and these districts periodically to see if Section 2 applies still, rather than totally dissolve it, totally nullify Section 2. Because if that happens, about 20 districts will turn. We talked about that, and I'm kind of nervous about that, especially after comments by Kavanaugh saying these laws should have sunset a long time ago, and some other remarks by the conservative majority. I was nervous. I'm a little more nervous about this than I was about that. Yeah. I told you that I thought the tariffs were going to get struck down. Especially on the back of Amy Coney Barrett's comments about the credit card you leave the babysitters and then you take the kid on a 2-day vacation to Disney. It's not in the spirit of what the parents told you when they gave you the credit card to take care of the kid and show him a good time. She brought that example up when Biden tried to push through forgiveness on student loan debt. That was her argument then, and I felt that would be her argument in the tariffs case, and it was. And Kavanaugh got on board, or Roberts got on board, and a couple other conservatives got on board, and I thought the tariffs wouldn't stand, and we were right about that. Well, I'm telling you right now, this one is bleaker, because as I disseminate their argument, and I think about who's on the court now, it's all about, can they get the judges to reinterpret the 1898 Wong Kim Ark decision? Okay? Can they get them to reinterpret that? Can they fit Trump's executive order? Can they fit that within the bounds of the 14th Amendment? And can they get the Supreme Court to reinterpret the 1898 decision? Okay, now the Wong Kim Ark decision went like this. Foreign national parents, Chinese. They moved to San Francisco. They are domiciled by the government, considered domiciled, as opposed to transient, considered domicile. Put a pin in that. Then Wong Kim Ark goes off and he travels the world for a little while. And when he returns to San Francisco, he's denied entrance. They say, you're not a U.S. citizen. You're not a U.S. citizen. Okay? They said your parents are not subject to the laws of the United States because your parents are foreign nationals. They are subject to the laws of the Chinese government, not the U.S. government. That was the argument at the time, trying to strike down the 14th Amendment. The 14th Amendment was in reaction to the Dred Scott case. It was basically an effort to get freed slaves to be citizens, right? That was the whole point. And it was challenged 30 or so years later with this decision. And they said, yeah, these foreign nationals, these foreign Chinese nationals, they're not subject to our government and our politics. They're subject to Chinese government and politics. Therefore, their child's not a citizen. Right? They looked right at the wording in the 14th Amendment, and the Supreme Court disagreed with them. But this is going to be something that originalists, which we have a number of on the Supreme Court, originalists are going to be specifically interested in. They're going to be specifically interested in the reinterpretation, because when they look at this, okay, this is really all about adding clarity to the founder's intent. Adding clarity to the founder's intent. Originalists are very interested in getting to the bottom of what our founding fathers really meant. Or more specifically in this case, what they could not foresee. Like our illegal immigration issue. You see, illegal immigration isn't mentioned. It's not mentioned in the Supreme Court's decision. It's not mentioned in the 14th Amendment. Because illegal immigration wasn't really a thing at that time. How could they foresee it? And that is a lane for John Sauer and the executive order and the Justice Department. That is their lane. That is their lane to strike in. That is where they can move around, find the space a little bit. Can we get Amy Coney Barrett and Kavanaugh and maybe a couple others to say, look, our founding fathers could not foresee the immigration crisis. They couldn't see this birther tourism coming. So because they were unequipped at the time to make a decision on this, we're going to go ahead and make it for them now. Uh-oh. And that's not the only uh-oh. When you start to dig into their arguments and the counter arguments and the counters to those arguments, there's more uh-ohs. This has been an effort that has been going on for decades. It's an effort that's been going on for decades. This current iteration of the attack on birthright citizenship. It's an effort that was going on in 1898 and at the turn of the century by legal scholars, prominent experts in the field, and voracious racists. This has been tried before, and this current iteration has been in the works for 20 years.
It's time for a quick break, then we break some more. You're listening to Brett Breaks Things. Brett Breaks Things, where the stakes are high and the truth still matters.
Okay. Let's take a look at the uh-ohs. Let's just look at it and see what's happening here. And I'm gonna distill it down and break it down, and I'm gonna frighten you as I have been frightened. Because as I hit these uh-ohs, it's not about does you or I feel these arguments hold water. We have to consider, are these arguments salient enough for this particular Supreme Court? Keep it in that frame of mind, right? Frame it like that. Not are you disgusted by the effort, and not do you find it completely weak and, incoherent or whatever. It's will this Supreme Court consider it? Will they agree with the Justice Department and John Sauer's arguments? First, let's really look at the Wong Kim Ark decision, okay, 1898. The Trump administration keeps bringing up the Wong decision. They keep bringing it up. And they point to the 20 times in that decision that say Wong Kim Ark's parents were domiciled. They were domiciled. They were domiciled. They were domiciled. Which means you are a resident there. To be domiciled, they take in consideration your length of stay in the country, your immigration status now, but at the time, it was a different view, different set of rules, but they took a look at your immigration status. They took a look at where you pay taxes and where you claim you intend to stay. People who don't normally get domiciled, tourists with a B2 visa, students with an F1 visa, temporary workers with an H1B visa, and certainly not illegal aliens or immigrants or undocumented immigrants, depending on who you talk to. Certainly not them. Okay. So they keep pointing to, well, yeah, the court ruled that way because Wong's parents were domiciled, which these undocumented immigrants are not. That's one thing. That's one thing. Okay. Also, when you look at some of the wording, and I dug into the wording of the opinion given at the time, this is what the opinion said. Anyone born in U.S. is a citizen, regardless of parents' nationality. The Supreme Court, in their opinion, wrote nothing about their legal status. They were saying, you can't deny the parents, you can't deny the citizenship of a baby whose parents were foreign nationals. If they're here and they're under our laws on our soil, it doesn't matter what nation they're from. They didn't mention their legal status at all. That's a hole that John Sauer's going to try to make bigger and bigger and bigger so Kavanaugh and Coney Barrett and Robertson and they can see right through it to the other side. That's a hole right there. I'll continue. The ruling went on to say no children of foreign diplomats can be U.S. citizens. No children of enemy occupiers can be U.S. citizens. And people with tribal allegiances cannot be citizens. The Indians. No Indians is what that ruling said. No Indians. They claimed, or how it's been interpreted rather, is that Indians own allegiance to their own nation. Cherokee, Seneca, whatever it may be. They have their own nation and their own allegiances. They are held to their nation's politics and governance, not ours. No Indians. Well, Trump's administration, the DOJ, they are seizing on the tribal exception. They are seizing on it. They are saying, undocumented immigrants are similarly not subject to the nation's political jurisdiction. Like the tribes, the administration says illegal immigrants owe allegiance elsewhere. Also, they're saying that they should be exempt from this because simply they broke our laws to enter the country. So, they are attacking their targets. They are attacking the wording in the 14th Amendment, and they are attacking the wording in the Supreme Court's opinion about their decision at the time. They're going to seize on the Supreme Court's decision not mentioning legal status. They're going to seize on the fact that undocumented immigrants come from a country that they have their allegiance to and entered our country illegally. They have no allegiance to us, and they got here illegally. Therefore, the 14th Amendment does not apply to them. Now, the lawyers for the ACLU and the people representing these parents, they have their counter arguments. But before I even get to their counter arguments, even though the Supreme Court said, born on U.S. soil, regardless of nationality, you're a U.S. citizen, the way you and I and the legal community for the last 125 years has interpreted that is that if you're born here, you're a citizen, we're done here, Supreme Court backed it up. But when you view it through the lens of an Amy Coney Barrett, who is an originalist, when you view it through her lens, she might just say, yeah, our founding fathers and the people who wrote these amendments, they could not have foreseen our illegal or our undocumented immigrant problem, our undocumented citizen problem. They couldn't have foreseen it. That's why they didn't mention it. That's why they didn't rule on it. That's why it wasn't mentioned in the 14th Amendment, and that's why it wasn't mentioned in the 1898 decision. So, we are going to make the decision for them. I see chaos. I see chaos. And, you know, there was chaos on the horizon with the tariff decision. Even Kavanaugh himself said, yeah, I recognize this could get messy. John Sauer kept circling back to that in his argument, saying, you can't just undo these tariffs. All these people will need their refunds. It will be absolute chaos. It will freeze us up. It'll seize us. It'll be nuts. And Kavanaugh acknowledged it, and Roberts acknowledged it, and they still ruled against the tariffs, which tells me that they will probably see the chaos foretold here like they did then. If they didn't let the chaos affect their decision with the tariffs, they won't let the ensuing chaos now affect their decision. You tell me there's going to be chaos? Who's a citizen, who's not? Will the government go after people retroactively? What does that look like when they start to try to, delineate your lineage and find out, oh, right here, these parents begat this parent who begat you. Well, those parents, they were undocumented. They were not subject to the laws and governance of the U.S. Those people got here illegally. Everybody's here illegally. So true, Scotty. Scotty said they'll use AI for that. Oh, Palantir is ready and waiting, right?
Wait till they secretly buy all those 23andMe
You
DNAs.
just took it right out of me. You just ripped
Bro, like they start matching that with our citizenship records and everything else, which by the way you can very easily find on ancestry.com and all these other things. You can go through they just insert all that in AI. They get rid of all the footwork, all the human, having taken all that time to go through that shit.
Oh,
excuse me, but that's what it is. And then all of a sudden, bam. Now they're going back 3 generations, 4 generations, and everybody. 5 generations gone.
Everybody. You just ripped the thought right from my head, Scott. Stock in 23andMe will go through the roof as the government subsidizes their data banks, seizes them, takes them, buys them, whatever, and goes through all of our genetic history, our whole familial timeline. And if at any point down the line they find you are an undocumented immigrant while we had laws in this country, you're all gone. You're all gone. That kind of chaos, I think the Supreme Court will be unaffected by that chaos as well. They will make the decision that they see fit, that they see fit. They will make the decision that will set the precedent. And we'll let, CBP, ICE, the DNI, the CIA, we'll let you all work it out. It's your problem now. We made our decision. Now go do your job. Go do your job. Do whatever you want to do with our decision. You go do your job, not our problem. Not our problem. Legal experts are talking about this. One woman who wrote a book called Trump's what was the name of the book? She wrote a book called Trump Might Have a Case on Birthright Citizenship. She said, "We have seen enough to convince us that this question was not open and shut, that conventional wisdom may not be correct, and that the Trump executive order has more going for it than people realize." And there's other opinions. Theories and ideas that were once far-right fringe ideas have become adopted by this administration and made into policy. The fact that the administration is taking these extreme actions does not transform them into mainstream action. It does not make them legal. We'll see about that. Taryn Wilgus from the Democracy Defenders Fund. We'll see about that. We'll see about that. There are arguments being offered up. Some of the arguments are, look, anybody who comes to this country are subject to your laws, no matter where they came from or what their nationality. As soon as they get here, they are subject to the laws thereof. Meaning, hey, you guys want to track us down per your laws, lock us up, restrain us, throw us in a cell per your laws? If this is a possibility, then they are subject to your laws. That's one argument. And there's others. There are arguments. There is hope.
We'll be back to break it all down. You're listening to Brett Breaks Things. You're back with Brett Breaks Things, because silence isn't an option.
So there are arguments, and, the lawyers representing the parents, they say you're going to sideswipe a lot of good people who have been in this country and have been contributing to the American dream and have hurt nobody, like students with visas, people on work visas, people with temporary status, people with asylum status. These type of people will all get sideswiped with this because none of them are domiciled, right? Their immigration status is other than what was mentioned in the 1898 decision, right? We're gonna make our way around it. We're gonna poke holes in it. We're gonna poke holes in it that are large enough for Kavanaugh and Amy Coney Barrett to see through. This has been an effort that has been tried before. Back in a time when being of prominence and education and racist leanings was commonplace and accepted. And you could do things like try to argue to the Supreme Court against separate but equal, or try to argue to the Supreme Court that we should have never abolished slavery. There was a time when arguing that side of the case was socially acceptable. Okay, there was a time when it wasn't reprehensible and the end of your career should you try to argue that side of one of those cases. We're talking about Alexander Porter Morse's era. Mr. Morse, Alexander Morse. He was a Confederate officer during the Civil War and a Louisiana attorney. And he argued that there should be a legal separation between the whites and the blacks. Okay? He argued that. That led to Supreme Court cases that established separate but equal doctrine and, did away with Jim Crow's laws. It was Plessy versus Ferguson, rather. That is the name of the case, actually, Plessy versus Ferguson. A lot of you know that. It was Morse on the other side of Plessy versus Ferguson. That was Morse. Morse and two other guys. They were the spearhead of this racist movement, this legally founded racist alternate movement, arguing the other side of these landmark race equality decisions. It was Morse, a guy named Francis Wharton, and a guy named George Collins. These three guys, all lawyers, all racist, they tried this before. This is their playbook. And Don is running it, directly running it, as the Trump administration's DOJ is directly citing a few of these gentlemen in their arguments. Arguments that failed over 100 years ago are going to hopefully fail again. Hopefully. Hopefully. Some people are saying flat out the fact that the Trump administration can cite a guy like Morse or a guy like Wharton seriously shows how weak their case is. Well, again, you may see it as weak. I may see it as weak. Does the Supreme Court see it as weak? Okay. Trump administration, as far as the 14th Amendment goes, they're in a tidy manner. They're saying the 14th Amendment does not apply to people in the country illegally or on temporary visa status. That is what the administration is arguing. That is what the executive order is establishing. Okay? This guy Morse. So he's a racist. This guy Morse was a racist. The Trump administration attorneys cited him directly in their Supreme Court brief. The Constitution excludes the children of foreigners transiently within the United States from qualifying for citizenship. Morse argued these very words while he was advocating for limiting all of the Reconstruction amendments and doing away with all the Reconstruction amendments, and was arguing vociferously against abolishing slavery. We should not have abolished slavery. And he was all bent out of shape about the possibility for black people to vote. Argued against that as well. He was a rabid racist, and the Trump administration is citing him directly in their briefs to the Supreme Court. Around that time, thousands of Chinese were settling in the western states, right? They were building railroads, digging mines, doing other jobs. And the idea that their babies, while they were here doing these jobs, would be United States citizens really scared the racists at the time. Racists like Francis Wharton, one of the other gentlemen who tried this already and is a rabid racist. He was a prominent legal scholar. He was a State Department official. Oh, yeah. And he tried, and you tell me if this sounds familiar to anybody that gets in front of a mic these days. You tell me if this sounds any familiar at all. He tried to formulate a legal rationale that based on the parents' nationality, they should or should not be allowed citizenry in the United States. That's right. That's right. You tell me who that sounds like. Now, he said, the citizenship should be determined directly by where their parents are from. If they are immigrants, where are they from? He wrote that Chinese were insufficiently civilized and could never obtain the proper status because they, quote, regard themselves simply as strangers and sojourners. To admit such rights to an emigrating nation would not be merely to establish a foreign sovereign, but a foreign barbarism within our national domain. He didn't have a very high opinion of Chinese people. To put it very simply, he did not. He was saying parents from a allied country, and he argued European countries, good. Parents from China, bad. Sound like somebody who runs around talking about, we'd love to have Scandinavian immigrants, wouldn't have a problem then. But these Somalians, they just can't integrate. They just don't follow our laws. Their culture's too different. Sound like anybody these days? And then there was the racist and San Francisco attorney George D. Collins, who joined in on some of these cases and had his own opinions. Prominent attorney. Oh yeah, prominent attorney. Chinese immigrants were utterly unfit, wholly incompetent to be American citizens. Are Chinese children born in this country to share with the descendants of the patriots of the American Revolution the exalted qualification of being eligible for the presidency of the United States? And he's basically saying, oh my God, if you make these Chinese people citizens, one of these Chinese people could be president. Ah! Oh, yeah. Yeah, that's the type of racism that, although scary, isn't as scary as the racism today. And I'll tell you why. Because that racism is overt. I see it coming. I know who's saying it. I can keep an eye on you. You're giving me your argument. You're open about it. We're on an even playing field. Here's your arguments on why it's better to be racist, and I can present mine on why you're a racist. It's the racism today, man. The racists who know it's socially unacceptable to be racist and harbor their racism in secret on little text chats among conservative circles or throughout our DOJ and other places where it's uncovered itself, like secret little cabals of racists who know damn well the optics of being found out they are racist. The sneaky racism, the racism I don't see coming, the ones hiding in the corners, lurking in the shadows. If anything, you can thank the MAGA movement for uncovering some of it, right? As he makes it more and more acceptable to kind of come out of that closet. The president is making Michelle and Barack apes on a social media tweet. He's clearly racist. The racists know he's racist, and then he dog whistles to him. So you got to give him that at least. He's bringing them out of the weeds a little bit. Oh, they come out. They think it's safe. They look around, and everybody else is like, there you are, racist. I see you on social media. Gotcha. He's racist bait. He's racist bait if you want to identify the racists. Yeah, man. So John Sauer's arguments, man, they really mimic what these three prominent racists were saying at the time. They really do. John Sauer is saying the citizenship clause applied to the recently enslaved and their children, not children of temporary visitors or those here illegally. Birthright citizenship is a powerful incentive for illegal migration. It presents national security concerns because some people illegally enter the United States to carry out hostile acts and facilitates birth tourism, foreigners traveling to the United States to have babies so their children can be U.S. citizens. So they're trying to appeal to, the Supreme Court's sense of America. This is not American. It's a threat to Americans, and they're using us. When you start putting stuff like, the Supreme Court has to do something about this national security threat. We're going to incentivize people to come here to carry out hostile acts. When you start jamming that type of stuff, that fear-mongering into a brief to the Supreme Court, that doesn't hold the water with me. Again, hostile acts from foreigners, that's the DNI's problem. That's the CIA's problem. That's the NSA's problem. That's not the Supreme Court's problem. That should not be something that Kavanaugh or Coney Barrett or Roberts or any of them should be deciding to take a role in. Oh, I can improve national security by taking away birthright citizenship? Well, let's do that then. That shouldn't be on the table. You shouldn't be cramming it into your arguments. That's not their problem. That's not their problem. Some people see this as another one of those dog whistles, man. These guys were racist. He's using their arguments directly. He cited Wharton as well directly. He cited Morse directly. They cited Wharton directly. The subject to the jurisdiction thereof, it disqualifies children of illegal migrants and temporary visitors from becoming citizens because they can't demonstrate the necessary political allegiance to the United States the phrase invokes. They're citing portions of these racists directly. One legal expert said, I was really struck the reading of the government's brief, how familiar it seemed to that period. The government argument to a large extent relies on Morse and Wharton and people who are repeating what they said uncritically. If you strip that out of the government's brief, it looks really weak. She's saying, first of all, it's racist and they know it's racist. Second, it was weak then and it's weak now.
Brett breaks things where the stakes are high and the truth still matters.
Okay, let's keep hearing from a couple experts real quick, that want to speak to why is the government leaning on 125-year-old racist arguments to make their case now. Why? One expert, Lucy Saylor, she said the challenge of mounting a credible argument against birthright citizenship, which has long been accepted as legal bedrock, may explain why the administration relies so heavily on Morse, Wharton, and Collins. They are not tapping into the central mainstream citations. They are using these people because they are the ones that are really pushing the ideas. Well, it turns out, look, if you're plugged in to the far-right evangelical political scene, what I'm about to tell you isn't a giant surprise. But there is a reason, Lucy, that the Trump administration, the DOJ, and John Sauer are leaning on Wharton, Morse, and Collins and their 125-year-old racist arguments. There's a reason they're leaning on them. Because the true architect of this iteration of the push to end birthright citizenship, the real architect of this round, is a man named John Eastman. I'll give you a second. I know that name. Yes, you do. He was one of the main architects of the 2020 fake electors plot. He was the one, along with Jenna Ellis and Rudy Giuliani and a few others, Mark Meadows, who were indicted in Georgia over that plot. He's in a lot of hot water these days. He's not a digestible figure to feed to the American people anymore. He is no longer one of the legal faces of the Trump administration, although he remains friends with them, spends time with them just recently. John Eastman, evangelical, right-wing stalwart. This push has been his baby. It's been his pet project. It's been his passion for the last 20 years. And along with citing Wharton, Morse, and Collins in their briefs, the DOJ is also directly citing words from John Eastman, but they're not crediting him. They don't want him attached to this for a few reasons. So instead of citing John Eastman's works and his briefs and his essays, which he's written over 100 of on this topic, instead of citing John, they're citing the racists Morse, Wharton, and Collins from 125 years ago. John Eastman, he has been doing this for a couple decades. 100 plus op-eds, law review articles, essays, and a recent media blitz have pushed his theories on birthright citizenship from the fringes and the corners and the dark recesses of the Conservative Party straight to the forefront and leading us to tomorrow. This has been Eastman's baby. Eastman has been working with the Federalist Society, he was actually paid by them to take his theories and his arguments to strike down the 14th Amendment and tour the country and visit Federalist Society chapter after chapter after chapter and far-right fringy gatherings all across the country to push his theories and gain traction. For 20 years he's been doing this, trying to get lawyers and judges and legal scholars all on his side, make them see the light, help them see the veracity of his argument. Help them see the importance of pushing this issue straight to the Supreme Court. All of his work has leaned on the subject of the jurisdiction clause, the subject of the jurisdiction. That's the 14th Amendment hole they're poking. Subject of the jurisdiction. They are not subject to our jurisdiction if they're Indian and of another nation, or if they're from a foreign nation and came here illegally. They still have their allegiance to that nation. That nation still has jurisdiction over them, and they came here illegally to have a baby. That is the hole that they are poking in the 14th Amendment, and that is the basis of John Eastman's writings and TED Talks and all of his little gatherings. And that is the heart of it. Subject to the jurisdiction. He's arguing it requires mutual allegiance to apply. He's arguing that the person who comes here, they need to be domiciled, like Wong Ark Kim's parents were. Wong Kim Ark's parents were. They were domiciled here by our government. They were foreign, yes, but they came here domiciled. They paid their taxes here. They had intent to stay here. And the U.S. government had no problem with them doing that. Mutual allegiance. Eastman's saying, undocumented immigrants, there is no mutual allegiance there. They are not subject to the jurisdiction of the United States. Therefore, they can't be U.S. citizens. All their children. All their children. And that means if you are here in any temporary status or asylum status, well, the U.S. government has not given its allegiance to you. You're temporary. Your allegiance still lies with your home country. So you students and you people holding work visas, you people whose status is making its way through the courts, or those people who have been granted asylum, all of you owe your allegiance still to your home country. There's no mutual allegiance between you and the U.S. 14th Amendment doesn't apply to you. Get out. There's reasons why they don't want to attach John Eastman's name to this. There's reasons why they have to lean on prominent historical racists. One reason, in the former AG Bill Barr, and good friend of John Eastman, worked with him quite a bit, especially around that time. Bill Barr testified to the J6 committee about conversations that Barr and Eastman had had on this very subject. And Bill Barr told the J6 committee, well, John Eastman said, yeah, we'd like to get this done, but any executive order concerning birthright citizenship is going to fail. That was out of Eastman's mouth. Eastman says he's a liar. When asked about it now, Eastman says he's a liar. He's a liar. I didn't say that. I didn't say that. And there's this pesky little business of his mentor and best friend, Judge Clarence Thomas. That's right. He has a very close relationship with Judge Clarence Thomas. And his friend and legal mentor said in 2023 that the Constitution proclaims all persons born in the U.S. are citizens. At the time, Eastman called that a passing statement that he didn't really mean. Okay, so it's more than just the indictment in Georgia. It's more than just the indictment in Georgia. It's past statements you made, and it's political beliefs of your mentors who you call, not in their right mind at the time, just a passing statement. What else? Well, there's the little business of his permanent disbarment in California. Oh, yeah. Over the 2020 fake electors plot, egregious and deceitful conduct is the basis of the disbarment, and it's going on right now as we speak. So there's that little messy business of his disbarment. Okay. Now I'm seeing it a little more clearly. Buddy of the president has been working on this for 20 years. He sees his shot and he takes it. But by the time his shot gets taken and he starts to be leaned on for the briefs and the arguments given to the Supreme Court, he's not a suitable face for this movement. He's not usable. We can't use you. You're going to be disbarred. You said yourself this wasn't going to work. Your friend and mentor completely disagrees with all the tenets of your argument. This is getting messy. This is getting messy. So what do? They lean on racist Morse, racist Wharton, and racist Dillon. Got it. Got it. And legal experts are out here kind of laughing at the Trump administration and the DOJ like, yo, this argument's been tried, and all the guys you are citing are rabid racists from the past. Trump's got him on his Great Racists of America trading card set. Like, which he himself has a card. I'll move on from that. But, and people started asking Eastman about this because, like I said, you and I might not have been hip to Eastman's efforts in the deep corners of the evangelical far-right conservative movement. We're not hip to the scene. We don't have our finger on the pulse of that particular movement, nor should we. But those who did track Eastman's interests and concerns and passions, they did ask him a few questions. And they asked him, hey, John, do you have any hard feelings that the Trump administration's leaning on all of your work and all of your findings and all of your passion and giving you none of the credit? Does that hurt your feelings at all? And John, to his credit, said, that doesn't trouble me. Remember, Ronald Reagan used to have a sign on his desk that there's a lot you can get done in this town if you don't care who gets the credit for it. Okay. All right. So Politico, they pushed a little bit. Politico pushed a little bit. And they asked him flat out, did your work on ending birthright citizenship, did it lead to Trump's executive order? Did you write it? Were you the architect of that executive order? He said, I don't answer that question. I never disclose what kind of communications I have, and I don't deny that they exist. Okay. All right, John. Fine. All right. He said, if you think talks happened, then they didn't. And if you don't think talks happened, well, maybe they did. Take that. Justice Department declined to comment on Eastman's role. Spokesman for the White House declined to comment on Eastman's role. Got it. So, John Sauer is going to take Eastman's little baby to the Supreme Court tomorrow to try to end birthright citizenship. I'll check in with you then. Thanks, kids.
They'll try to repair the narrative, but Brett Breaks Things will be back tomorrow to break it all down.